Well, good afternoon, and thank you for joining us for the third webinar in a five-part series on employment compliance in government contracting. Today's program will feature a mid-year check on employment-related compliance efforts, as well as best practices for preparing for and responding to government audits. My name is Matt Kissling, and I'm an associate in Thompson Hine's labor and employment practice, where I primarily focus on advising government contractors and subcontractors on all aspects of employment-related obligations under federal, state, and local laws and regulations. I'm also joined today by Brian Stillwagon and Tom Mason. Brian is a partner in Thompson Hine's labor and employment practice, where he possesses a significant experience advising and defending employers during all aspects of wage and hour investigations conducted by the Department of Labor, as well as wage and hour legal actions and class actions. And then Tom is the chair of Thompson Hine's government contracts practice. And Tom has nearly 40 years of experience representing government contractors and subcontractors in all aspects of government contracts law, including management of major government systems and resolution of contract bid protests and disputes. Before we begin, we have some preliminary notes about the materials and the technology. Today's program is being recorded. It will be available on our website shortly after we conclude today. And questions will also be addressed at the end of the program. So if you could please submit any questions using the chat box on your side panel, that'd be greatly appreciated. And then we will address them at the end of the presentation today. Our presenters will try to address all questions, but we may not have time to get them all. So I understand that everyone is busy today. If we're not able to address your question during the presentation, we will make a point to follow up with you directly. And just a quick reminder about the presentation today. This is intended to provide educational information to you about legal matters of current interest, and so we do hope that you find the information helpful and enjoyable. But this presentation is not intended as legal advice and does not establish an attorney-client relationship with Thompson Hine or any of its attorneys. If you do have any questions or legal matters arising out of the presentation today, please don't hesitate to reach out to one of us following the webinar. So today we're really going to cover three principal topics. The first of which are really your key employment-related clauses in your government contracts, why they're important, and some of the potential consequences of non-compliance arising out of those clauses. And that's going to be discussed by Tom Mason to kick us off here today. Then we'll move on to Brian Stillwagon, where he will discuss wage and hour compliance concerns, as well as some best practices for preparing for Department of Labor investigations or audits. And finally, I will address mid-year compliance check on affirmative action matters, as well as preparing your organizations for potential OFCCP compliance audit. So with that said, I will kick it off to Tom Mason to get us started today. So Tom, you can take it from here.
Thank you, Matt. And what we want to cover just initially here are the way the Federal Acquisition Regulation treats these labor and employment standards. And quite frankly, we see all of the labor laws that we'll discuss today will be included in your government contract as a clause of the contract. And what's significant here is that the government affords itself not only with the rights that are afforded to it under the labor employment statutes and the regulatory provisions that enforce those statutes, but now the government has a contract remedy for those that are performing, bidding on and performing government-funded programs and contracts. I think it's really important to start with these because we're really talking about managing our most important asset, our people, our employees. And these clauses are put in the contract to reinforce the importance of these provisions in our day-to-day operations. I think it goes without saying that they're in the contract. The government expects to pay companies for complying with these regulations and statutes, and they're going to insist that the statutes are complied with. If we don't comply with one of these statutes, then we will invariably get a poor rating for our performance, a CFARS rating. And so I don't want to overstate it, but I also don't want us to think that there's no teeth to these provisions. Now, there are many, many clauses, and we've highlighted just a few clauses for us to think about today. On this slide here, we highlight the prohibition of segregated facilities. So if we have a waiting room, a work area, a restroom, a washroom, a conference center, a parking lot, etc., we must not discriminate, and we must not have segregated facilities pursuant to this clause. Several equal opportunity clauses, we've listed a couple here, and I want you to note two things with these clauses. Number one, these clauses specifically prohibit discrimination against a veteran in one case, workers with disability, race, gender, and other categories and other clause. They prohibit discrimination, but they require affirmative action all within the same clause. And 52222-37 is an example of a clause that requires reports. And most of these labor and employment provisions do require the delivery of what we would call a CEDRO, or a report to the government outlining compliance, and also notifying the government of any issues that may pop up. And my slide's on. There we go. 52222-40 deals with our obligation to provide notice. We use hotlines, we use conspicuous posters, we post on web pages. The fact that the company has labor and employment policies, and they're complying with these policies. And so you should look for the notice. As you walk the company area, you should see evidences of this, and if not, corrective action should be taken. Every contract now has a trafficking prohibition clause in it. 52222-50 is representative of that. And this is really a focus on sex trafficking and inducing commercial sex by force, intimidation, and this is probably the newest clause to be inserted into the clauses that we use and see in government contracts. I have two clauses listed on the on this slide. One deals with minimum wages, one deals with paid sick leave. I want to make a point with these. Number one, it outlines what we must pay an employee, when we must pay an employee, and there's several categories like this that are called out in the contract. And the principle here is, let's say that we're performing a contract and the law changes and the minimum wage goes up. Well, the contractor will get compensated for increasing the pay. That's a cost impact to the contract, and the contractor will get compensated for that. And again, the point is the government is willing to pay for compliance with these statutes and insist that contractors do so. With respect to the FAR in general, the FAR requires that we have a code of business conduct and ethics. And we should, each company, each corporate division should have its own code of business ethics and conduct, and it should be followed. Typically, these should be trained to. Employees should have training with respect to what's expected from not only ethics point of view, but a standards of conduct point of view. And there should be clear communication within every organization that the government employee, the employee of a government contractor, must maintain the highest standard of ethics and professional conduct. And this code of business ethics and conduct is useful in making sure that the company has policies to identify and take action if an employee misbehaves or engages in unethical behavior. And under the FAR, in addition to these clauses, there's a requirement to disclose, under the mandatory disclosure rule. And simply put, that a contractor who's performing this business is not expected to be precisely compliant with every clause every minute of the day, but we're supposed to use best efforts and our good faith efforts to do so. If we have a problem, we are to report it. And the mandatory disclosure rule goes hand in glove with the ethics program that a company has, which it should become natural that if we have a problem with our business practices, if we have a problem where we didn't pay the right wage and we were our bills were wrong, we simply report it. We simply investigate and take corrective action. A very easy policy to follow. In 2008, the mandatory disclosure rule was added to the FAR, and ever since that time, there have been administrative, contract, civil, and criminal remedies associated with violations of contract clauses. And if there's credible evidence of a misbilling, mischarging, any type of situation like that, there is a requirement under the contract as well as the statutes to make a disclosure, and generally we make the disclosure to an inspector general of the agency that we're serving or the DoD inspector general if we believe that there is a mischarge, overcharging, undercharging, or a problem with respect to our invoicing. And if we look, we had a webinar early on in the year where we talked about mandatory disclosure, and the topics that we're going to talk about today reflect that the most common contractor disclosures address labor mischarging. Labor mischarging, we're not using the right rate, we're not using the prevailing wage rate, we're not using the Service Contract Act provision correctly, we're not compliant with our contract clauses, and we charge the contract price. That's also can be a subject of mischarging, where the government expects the charge to be accurate, but it also expects the contractor to perform all of its obligations under the contract. So as we move forward here, and I think Brian's going to move forward from this point. If we move forward here, I want you just to remember that every one of these provisions that we talk about is included in a contract and affording the government with a contractual right to enforce that provision. Brian, I'll turn it over to you.
All right, thanks, Tom. So the Department of Labor, everyone's favorite topic, especially when they show up unannounced at your place of employment. I can think of few things more stressful as someone working inside the company than a government agency showing up and demanding to see your records, to talk to your employees, and so forth. So in this short section here, my goal is really just to give you some red flags to try to spot. This is a mid-year compliance check, so hopefully you can hear a few things to just take back to your company and go through these items and make sure that you are handling these things appropriately so that we can get ourselves in a good spot. So the Department of Labor, as many of us know, that's the key regulatory agency that administers several federal laws. The key ones we're going to talk about today would be the Fair Labor Standards Act, the Family and Medical Leave Act, and then also the Davis-Bacon Act and the Service Contract Act, along with several others. So what has the DOL been up to lately? They've had several years of increased enforcement. You can see that last year alone, they recovered a record $304 million up from the past 4 years. Over the past 5 years, they've collected more than $1.3 billion in back wages. So that is simply the amount of back wages. That's not an amount of punitive damages. That's no, necessarily penalties. That's wages that should have been paid out. This slide here, you can see the industries that were targeted most in 2018. Several of these are not going to be a surprise to you, but you can see the both the number of cases and then the total back wages. The largest last year, the most wages paid out were in the food service industry, followed by construction, and then down from there. So if you are in one of those highly targeted industries, even more reason to pay attention to this. And then this slide here, we see the DOL's enforcement, not just on the FLSA or the FMLA, but some of these government contract acts specifically. Last year alone, they opened 1,700 cases and found violations, and close to 1,500 of those, bringing in over $64 million. So what do we do to prepare so that if they were to show up at your place of employment, you are not going to be one of these companies writing a big check at the end of the investigation? So the biggest thing to do is to conduct a privileged, that's the key word, privileged classification audit. What does that mean? We're going to review the records and we're going to find out whether there is a problem with your payroll and wage practices you and your attorneys are going to find that out before the Department of Labor finds it out, or before a private plaintiff finds it out and brings a lawsuit against you. So I said privileged is the key word here. Why? Because the last thing you want to do is do an audit that is done internally without legal counsel. So your HR team, your payroll team, you go in and do this audit, you create a lot of records, documentation, send emails back and forth, you find there's a problem, and either you don't fix it, or you don't fix it soon enough, or you only fix part of it because it's too expensive. You've done the legwork to find out what the problem is, but perhaps your business unit counterparts don't want to make the change or aren't in a position to make the change yet. You've now created all of these documents that are not protected if litigation arises, and the Department of Labor comes in or a private lawsuit is filed, and now you have to turn over all of those documents that show not only did you know there was a problem, you had the wherewithal to go in and research the issue, but then when you found out that there was a problem, you did nothing about it. In my mind, that's worse than not doing the audit in the first place. So we have noticed some payroll processing companies, some of the big names out there, many of whom you probably use, and some other third parties have been offering these payroll audits, pay equity audits, classification audits as a service to the companies that they're providing payroll services for. We would warn you against using anything like that, because again, you've got to work with your outside attorneys to go through this process in a privileged manner to keep all of those documents away from the DOL and the other side. So what are the topics you're going to be looking at when you do this audit? The first big one is exempt classification. Again, I could spend an hour on each of these topics, but in the interest of time, I'll try to go through these somewhat quickly just to give everyone an overview for those who aren't familiar. So exempt and non-exempt, that's the legal classification for whether someone is entitled to overtime under the Fair Labor Standards Act. Many people think you can call someone salaried and not pay them overtime, and you only have to pay overtime if they are coded in as hourly. Those are payroll terms. That's how payroll department runs those individuals' payroll. Whether they are entitled to overtime, it depends on whether they fall into these buckets, these exemptions that Congress carved out under the Fair Labor Standards Act. For example, the executive exemption, that's why your C-suite is exempt from overtime. The professional exemption, that's why the doctors and lawyers have a hard time trying to say that we should get overtime. So there are these categories that you have to be able to fall into. So we want to make sure that our employees are properly classified there. Then you get down into the second point, which is, should they be classified as an employee at all? Or have we coded them as an independent contractor? Again, a lot of companies think that they can simply give someone a 1099 and keep them off of the books for overtime purposes, for tax purposes, for benefits purposes. Again, the Department of Labor has set out these regulations that you have to meet in order to be appropriately classified as a contractor. If you don't meet those criteria, you are an employee. It doesn't matter if you have them sign an agreement saying that they agreed not to receive any overtime, or that they will say that they are an independent contractor. The DOL is going to look at the facts and how that person operates. So if you have an independent contractor who's been with you for 2, 3, 4 years, who works alongside your W-2 employees on a daily basis, those are the people the DOL is going to be most interested in, especially if you have a large number of 1099s on the books. Proper wage determination categories under the SCA and your wage determination, you want to make sure that you've got your employees coded so that they're being paid the correct wage determination rate. Matt will talk a little bit more about that later on and in a subsequent webinar. And then finally, just another note, what we're talking about primarily in this webinar, especially in this section, is federal law. That's where these primary laws come into play, are on the federal level. But keep in mind that if you are in a regulatory heavy state, or even a city or a county, then you might be subject to very different exemptions and wage categories, wage levels for minimum wage, and so forth. So just want to flag that for you. So in the other thing, when you're going through to do this audit, you want to make sure that at least over the past 2 years or so that you have been paying your employees appropriately and that you've been documenting their payment appropriately. So the Fair Labor Standards Act, the two big things it covers is the payment of minimum wage, the federal minimum wage, and payment of the overtime compensation. Minimum wage we're all aware of. The overtime requirement is that you have to get time and a half of your regular rate of pay. Now, this is on a single work week basis, so you don't, for most employers, most non-governmental employers, you cannot have comp time. You can't work 35 hours in one week, 45 in the other, and say that you only worked 80 and so you're not entitled to overtime. It's a single work week. You multiply it by time and a half of the regular rate. So if that person is making $10 an hour, their regular rate is $10 and their overtime rate is $15. Keep in mind, though, that the regular rate includes all forms of compensation that employee receives, with certain exceptions. But for example, if you pay your employees non-discretionary bonuses at certain points throughout the year, that has to be taken into account when calculating not only the regular rate, but those bonuses are going to have an impact on the overtime rate. Third point on here, look out for off-the-clock work. You want to scrutinize some of the payroll records. If you see employees who are supposed to be keeping track of their time on a daily basis and clocking in their start and stop times or writing in their hours on timesheets, and you see that it is very common for employees just to write that they start at 8 and leave at 5, and that's what they've written for the past year or two, you probably want to dig deeper into that. That tends to be a red flag. Very rarely does anyone start their day at 8 o'clock every day and end at 5. A lot of times those people come back and say that they were forced to work off the clock. Same thing with during meal and rest breaks. If you give meal and rest breaks, you want to make sure that your employees are completely relieved of work during that time, since they are not being paid for that time. And finally, with deductions, you want to be very careful if you are deducting anything from your employees' pay. Many types of deductions are improper, so we want to go through and take a look at those deductions. Matt's going to talk a little bit about the SCA here.
Certainly. So if you do business with the federal government, and particularly if your organization provides services through the use of your employees to the government, then you do have some additional requirements that you have to worry about. That's under the Service Contract Act, where, as Brian mentioned a short time ago, those employees working on the contract need to be paid a set prevailing wage, which is really based on the classification that their particular position or job function falls into. And this is entirely driven by what's written in the wage determination that is provided with your contract. So if you know that you have a service contract with the government and you don't see a wage determination in there, you should probably call up your contracting officer contact and ask them what the heck is going on here, because at the end of the day, you're still going to be expected to pay the prevailing wages and the fringe benefits. And if an issue arises and the DOL comes in and starts poking around, they're only going to care so much that there's not a wage determination in the contract. They're basically going to hold both you and the contracting officer accountable for the absence of the wage determination and the lack of any prevailing wages. So really the key point here is to go back in whether during self-audit or even just looking through your files to make sure that the wage determinations are in there. And then during your self-audit, make sure that the proper prevailing wages are being paid. The same goes with health and welfare benefits, where this is something that's determined on an annual basis by the Department of Labor, where it's for contracts that were entered into prior to July 5th of this year. It's a $4.41 per hour required health and welfare benefit that must be provided to employees. This can be captured in a variety of ways, whether it's through health insurance or pension or 401k contributions, or even have the option to pay an additional $4.41 an hour to the covered employees in lieu of providing them any of those benefits. One of the important things to remember here is that if you choose the cash option, it actually needs to be paid separately from the normal prevailing wages. So on a pay stub, it can't be lumped into the normal hourly rate. Instead, it needs to be laid out separately as its own independent cash equivalent. And the same goes if you provide benefits or a combination of benefits and cash contributions. The amount of the contributions on all those fronts need to be clearly laid out in any sort of wage records that you keep for your employees. So it does impose some pretty hefty record keeping requirements on top of the fact that you need to worry about your contracts and pay your service employees more than what you may be paying other staff members. There are also some certain paid vacation and holiday requirements that are laid out in the wage determination. These tend to be more seniority based, where kind of the default is either 1 week or 2 weeks of paid vacation after 1 year of service, and then it increases as the seniority of the employees increases. And then you're also required to provide a certain number of set paid holidays to employees, and these typically track the typical federal holidays, but there may also be a couple of additional floating holidays out there that you'll need to worry about. And then lastly, everyone's favorite topic, paid sick leave. Again, Executive Order 13706, which went into place back in 2015, 2016, and applies to any service contracts from 2017 forward. You're required to pay 7 days of paid sick leave annually for employees working on any of those contracts. Brian mentioned before, during your audit, you want to look at your compliance with state laws. This federal paid sick leave requirement essentially sets the base. If you have employees in a state that has higher paid sick leave requirements, such as Washington, New York, New Jersey, a lot of the states on the coasts, then only providing the federal paid sick leave isn't going to cut it. You also need to worry about and make sure that you're providing employees the required amount of state paid sick leave as well.
Perfect. And if that wasn't hard enough to administer, if that doesn't give you enough to do, then everyone's favorite administrative nightmare, the Fridays and Mondays Leave Act, called by our government the Family and Medical Leave Act, an act very prone to abuse, a very helpful law, but one that is subject to abuse, unfortunately. Those of you with 50 or more employees, not just at one site, but if you have multiple sites within a 75-mile radius, you're going to be covered by that. The DOL, if they come knocking, will want to make sure that you are complying with that you're giving 12 weeks of unpaid job-protected leave to your covered employees who have worked there for at least a year and have met the hours requirement. All right, last two preventative maintenance ones I'll go through quickly. Just check your record keeping, especially for your non-exempt employees. You're going to have a lot of records on site to prove that you've been paying your employees correctly. Unfortunately, the DOL is not going to trust you or just take your word for it. So this is some of the documentation that you need to have in place, again, especially for your non-exempt employees. Keep in mind that making sure you have the right classification is step one, because if you have exempt employees and are therefore not tracking the number of hours that they work each day and each week and their rate of pay, but you have misclassified those employees, the burden is on you, the company, to show how many hours they worked and how much they were paid. And if you haven't been tracking that because you thought they were exempt, you're going to have a very difficult time in litigation, and very often we have to defer to what the employee says he or she worked during the time, and it's amazing how suddenly when they come back and sue you, they were the best employee and were pulling 80-hour weeks. So make sure you have your documentation in order. Keep your eye on I-9s. Last one here, before the DOL comes on site, you want to make sure your posters are properly posted. That is one of the things that they will have their eyes open for, and they will want to see where all of those posters are up in a prominent place in your workplace. Lastly, review and revise your policies. You want to encourage employees to report violations, these wage violations. Why? Because you would rather fix them preventatively than be told to fix them by the DOL or by the court. You want to make sure that you include this in your anti-retaliation policy, that no one should be scared about bringing these sorts of reports to you. You want to make sure that handbooks and policies are compliant with the law. These are two common sentences that I've seen before in handbooks. First one, PTO is accrued but is not paid out at termination. that might be a violation of your wage determination. The second one here, for overtime to be paid, you must receive approval in advance. That is illegal. If you work overtime and you weren't supposed to, you can discipline, you can even terminate that employee, but you have to pay the employee. Consider having your employees sign arbitration agreements with class action waivers. Again, I could go on for an hour about these, but the Supreme Court has found these lawful, and talk to your attorneys about rolling these out. They reduce the risk greatly for your company. And then lastly, you train your managers and your employees on sexual harassment and racial discrimination and those topics. You need to train them on wage and hour policies as well. They have just as much, if not more, of a financial risk and impact on your company. So last slide here, what to do. All right, so that's all the prep work that you have done. Now, what happens if the DOL comes knocking? They're either going to come knocking because of a routine and random, quote unquote, random audit, or more likely, because they are strapped from a resource standpoint, more likely they're going to come based on complaints and reports from employees and former employees. So first step, notify your attorney and senior management. In the event that they do show up without announcing themselves ahead of time, you can ask them politely to reschedule their visit if it's in a time that does not, that causes a big burden on your company's operations. If they push back on that, then again, politely say that you just need to have your attorney present for that so that they can reschedule and you will have a time to get ready with your attorney and the rest of management. The big one here, these investigations have a huge personal side to them. Be cooperative and friendly. These investigators are generally not attorneys. They are used to coming into places of work and being brushed aside, being abused, being told that they have no authority, being given the runaround. So they come in very much on the defensive or the offense, ready to fight, because that's what they're used to seeing with a lot of these companies who are skirting the wage laws. So if you can very quickly show that you are willing to cooperate and help get them whatever they need, that starts things off well, and it has a huge impact as the investigation goes on. The investigator has great discretion in how narrow or wide of a scope of investigation that he or she carries out, and the more you can get on the investigator's good side and limit that scope, your company will be in a much better situation. You working with your attorney is going to help you limit the scope of the investigation. So just because the investigator requests a great deal of documents, you might be able to work with your outside counsel to limit the scope of the documents you turn over. You only want to turn over what is absolutely necessary. You don't want to turn over documents that they have not requested or that they maybe don't need to see yet, especially if it shows further violations that the department doesn't even know about yet. So, and again, even if you've been doing everything correctly, you just don't want to give over more documents than you need to, just because you run the risk of them finding even an inadvertent error that's been made on your side. The attorneys go to the interviews with management. So when the DOL comes on site, they want to look at documents. They will also conduct some interviews. You and the attorney cannot sit in on the interview with the rank and file employee, but we can with management, and we want to make sure that we do take advantage of that right. And lastly here, with anyone who takes part in the investigation, your employees who are interviewed are probably scared or worried about why the government is coming in to talk to them. Just reaffirm with them the company's non-retaliation policy, that you appreciate them taking part in this process. Sorry for the inconvenience, and whatever they say or do, they will not be disciplined for taking part in that process. So that's a lot. If you have any questions, follow up with the team later. Matt.
Thank you very much, Brian. So as if the wage and hour division within the Department of Labor isn't enough to worry about, I'm going to talk for a few minutes about everyone's other favorite organization, the Office of Federal Contract Compliance Programs. I'm really going to focus on, what can and should you be doing now to make sure that you're up to compliance, as well as what you can do to prepare for a potential OFCCP audit, as well as being in the best position possible to respond should an audit come in the door. So where are we now with the OFCCP? On March 28th, the agency released their annual corporate scheduling announcement list. In years past, they sent courtesy letters to contractors, letting them know whether or not a particular location has been identified for an audit. They did not do that this year. Instead, they posted the list on their FOIA page on their website. In that list, they identified 3,500 individual companies and facilities for audit in 2019. This is nearly double the number from 2018, and I think of roughly triple the number from 2017. Now, about 2,300 were identified for what we call a traditional establishment review, which is where the DOL sends you a list of about 22 different document and information requests, and you have 30 days to respond. 500 were identified for a Section 503 focus review, which is a new creature and really focuses entirely on compliance with the disability affirmative action obligations under the regulations. The interesting note here is that since this is the first year that they've rolled out this focus review, they've only identified corporate headquarters locations for these focused reviews. And what they're going to do is send you a more condensed list of document requests, as well as come on site to make sure that corporate headquarters is doing everything it's supposed to be doing from a disability perspective. And then finally, about 500 locations were identified for a limited compliance check, which is really just a basic request to submit documentation showing affirmative action compliance, whether it's a copy of an affirmative action plan or some other documentation showing that the facility is doing everything it should be doing from an affirmative action angle. The consequences of not complying can be pretty steep. In 2018, OFCCP entered into 47 conciliation agreements with contractors and subcontractors. These agreements can cover both technical violations such as record keeping or AAP compliance, as well as financial violations where they come into an audit and actually find evidence of various types of discrimination. Their favorites in the past couple of years have been hiring discrimination as well as compensation discrimination. And so far in 2019, OFCCP has entered into 61 different conciliation agreements, and 20 of those have involved financial penalties for a total of about $7,662,000 in back pay or financial penalties. Now, the wrinkle of these conciliation agreements is even after they're signed and done with, and the contractor's done everything that they're supposed to under the agreement, that's most likely not going to be the end of the story. That automatically puts that particular contractor and location on the government's radar for a follow-up audit, probably within a 2 or 3 year period. They'll come back in and start all over again and ask for the same types of documents and potentially even come on site to see how everything is going. So what can we do to make sure that you're up to speed from a compliance perspective and you're well prepared for potential audits? It really starts with preparing your affirmative action plans. As you may know, these are plans that need to be prepared on an annual basis. So if you haven't put them together yet for 2019, you should strongly consider doing so now. We're certainly happy to help you in that regard. But it's really a numbers perspective. And an individual plan is required for any location that has at least 50 employees. If you have less than 50 employees, you have a couple options. You can either roll it into the corporate headquarters plan, you can prepare an individual affirmative action plan for that less than 50 location, or if you have more of a regional HR structure, you can consolidate all those under 50 locations into more of a regional plan for basic compliance purposes. The key thing to remember here is if you get audited by OFCCP, then you definitely want to separate the target facility from all other locations in an affirmative action plan. Otherwise, the OFCCP will take the approach that they have jurisdiction over all those other facilities that were rolled into that plan with the target facility, and so then they could expand their audit and their investigation appropriately. So that's definitely something you don't want. You don't want them to be sniffing around any facility other than what they've identified and sent you the letter about. Now, from the nuts and bolts of the affirmative action plans, the first plan that needs to be in place is for females and minorities. This is a traditional plan under the executive order. This really has a couple of main components. The first are the job group and organizational profiles. And what these really do is they outline the demographics of your workforce as of a snapshot date. And then they divide them and break them down by race and gender, from a job group perspective, your EEO1 job groups, that's the typical approach. And then also from an organizational perspective, how you internally organize structures. They certainly don't expect you to, have your internal structure departments match or mirror the EEO1 job groups. So if internally you divide positions into departments or other reporting structures, that's what the organizational profile is designed to capture. The next required component are the underutilizations and placement goal analysis. What this looks at are the percentage of females and minorities in your workforce versus the expected availability under a statistical analysis, and that's based on census data. And again, if there's an underutilization and a particular group exists, then a placement goal is then established equaling the percentage of expected availability. And the point there is if there is a placement goal, that's the target for your next year's outreach and recruitment efforts. Is your goal is to really try and achieve that placement goal, or at least make significant progress and reduce that placement goal for the year. Another required component is a description of your implementation plan. The OFCCP will want to see how do you actually implement your affirmative action plan. It's one thing to have it in writing, have this written plan together. What steps are you taking to actually put it into place? An audit and reporting procedure. This is really a process for how you monitor your progress on your affirmative action goals, as well as your outreach and recruitment efforts. And it goes hand in hand with this next point here, the description of outreach and recruitment. What the OFCCP really looks for here is what steps are you taking in a particular year? What to promote the hiring and retention of a protected class? What organizations are you working with? Colleges, universities, local communities? What internal efforts are you taking, such as training opportunities or promotional opportunities, stuff like that? Plan should have all that in writing and should provide really a high-level description of the steps that you're taking in those areas. And finally, you need to have a copy of your sexual harassment policy as well as your procedure for investigating potential complaints. This can really be accomplished one of two ways. If you have an existing policy, separate from the plan, you can just throw it into the plan and have it in there, or you can also write it out separately into the affirmative action plan itself. It's really up to you how you want to structure that. So outside of females and minorities, the other component is the affirmative action plan for individuals with disabilities and protected veterans. These requirements were overhauled in mid-2015, and as evidenced by the Section 503 focus reviews that are rolling out this year, this is going to be a heightened area of focus for the agency moving forward. And one of the key components here is you need to have a description of your reasonable accommodation procedures. The government wants to know, how do you handle requests for reasonable accommodation? Are you engaged in the interactive process? And then how do you ultimately determine what accommodation to approve for a particular employee who needs one? They also want to see a description of your review and of your physical and mental qualifications. What this is really asking for is, are you on a periodic basis going back through your job descriptions and making sure that the physical and mental qualifications are truly tailored to the position and are absolutely necessary? The reason for that is, if you have certain qualifications, that may prevent an individual with a disability or a disabled veteran from being able to enter into that position or work for your company. And so as long as those qualifications are truly required for the position, that's going to help you down the road defend a potential discrimination claim in that area. I mentioned, similar to the executive order plan, the government wants to see a description of your outreach and recruitment efforts specifically tailored to veterans, individuals with disabilities. So what organizations are you working with that cater to or promote either of those protected classes? You also want to see, again, a description of your audit and reporting procedure. How are you monitoring your progress from an affirmative action angle? And some kind of the more statistical components, you need to have a description of your hiring benchmarks and utilization goals. As you may know, the regulations require an annual hiring benchmark for protected veterans for an individual facility, and you also need to have set a particular utilization goal for individuals with disabilities for each of your EEO1 job groups at a location. That utilization goal is 7%. So, the purpose there is to set a goal of having at least 7% of individuals in each job group, be folks who self-identify or otherwise known as individuals with disabilities. And finally, you need to have a description of your data collection analysis. What the regulations require here is that on an annual basis, you collect and analyze certain applicant and hiring data for individuals with disabilities and protected veterans, and compare that against your overall numbers from an applicant and hiring perspective for a particular location. So outside of the written affirmative action plan, that's obviously a lot of nuts and bolts to worry about. And another key thing you need to do, put yourself in a good compliance position is to verify your job postings. I mean, really the question to ask yourself here is, do you know where your job openings are being posted, once they're created? Are they on your company website? Are they through third parties such as LinkedIn or Monster? And most importantly, are they going to state and local workforce agencies? And that's critical because the regulations require that any job openings for your locations are being referred to, or at least information about those jobs being provided to a state and local workforce agency, and so that then they can post them on their job boards or otherwise engage in targeted outreach for protected classes, in particular individuals with disabilities and protected veterans. So what you should do is you should verify that your openings are being sent to those state or local agencies. Here in Ohio, it's the Department of Job and Family Services. New York, it's the New York State Job Bank. So, I believe the OFCCP actually has on their website has a list of the state job banks for each of the 50 states. So if you aren't sure where your job should be going, go to the OFCCP's website, and they should be able to provide you some basic contact sources on that front. Another important thing to do is to track when and where the openings are posted, as well as make sure track any applications that you then received from those postings. This can be accomplished simply by including on your application an opportunity for someone to tell you how they found out about the job. What was their referral source, and they may say a local job board or state job board or LinkedIn or something like that. And if that information is provided, it's something that you want to track, because we've seen the OFCCP start asking for that verification that the jobs are being posted and that where your applicants are coming from. Since we're on the topic of applicants, another key compliance thing you should do is really undertake a review of your applicant tracking procedures. It starts with self-identification surveys. This is how you get that basic protected class information for gender, race, ethnicity, disability status, and veteran status. You want to make sure that you're actually asking these, making these voluntary surveys. First, are you doing it pre-offer as part of your initial job application? Is anyone who submits an application for employment, are they being given the opportunity to self-identify this information? If they choose not to provide it, that's fine. You just need to give them the opportunity to do so. The same goes post-offer. Do you want to hire somebody? As part of the onboarding process, you need to give them a second crack at the apple. Again, invite them to self-identify this protected class information. At the end of the day, it's purely voluntary. If they don't respond, if they don't wish to identify, that's their choice, and you'll be in a good spot as long as you're asking both pre-offer and post-offer. Another thing you should do is make sure you're appropriately tracking application submissions and then related dispositions of applicants. So from a starting point, you should make sure you track the date an application is submitted. You should also ask yourself and look at, are all applicants being properly dispositioned? So if someone does not possess the minimum required qualifications for the job, are they being dispositioned that way in your system? If not, that might be an indication that things are not being done the best that they can be, and so then you should take a deeper dive and look at your disposition policies and procedures. And finally, you want to make sure that you're maintaining all the necessary supporting documentation for your applicants. So the actual, electronic or paper applications, resumes, the completed or declined self-identification forms. If you bring folks in for interviews, make sure that your hiring managers and staff are keeping copies of those interview notes. If you use pre-employment testing, you want to make sure first that the testing has been scientifically verified. That's another requirement of the regulations. Then any results, you want to make sure those are being kept with the hiring file for a particular individual. And finally, any sort of hiring or onboarding materials that you have for someone who makes it through the application process and you bring them on as an employee. You want to make sure that that is all being prepared and kept as well. Since we're on the topic of record keeping, similar to what Brian mentioned before, there are a number of record keeping obligations that you should make sure that you're undertaking. the key thing to look at here is it depends on the type of file, whether it's a 2-year or 3-year retention. Your general hiring documentation and your affirmative action plans, at a minimum, need to be kept for 2 years. And they can be kept electronically or in a file cabinet as long as you have them available for a 2-year period. For a 3-year perspective, this really focuses on a lot of the documentation of your recruiting efforts or your data collection for veterans and individuals with disabilities. That all needs to be kept for a 3-year period. The one thing to note here is any reasonable accommodation files, that's a 2-year retention period, that should be kept separate from personnel files or other employment documents. The government and the EEOC are very strict on making sure that any medical related information is generally kept separately from the rest of your employment files. And finally, Brian again mentioned this earlier. This is something that the first thing the DOL looks for, or the OFCCP looks for, if they come to your facility for an on-site audit, is do you have all the required posters? So obviously the typical ones that EEOs love, but also some that are really specifically tailored to government contracting. First one here, pay transparency, non-discrimination. You want to make sure that's posted in your facilities, and that actually also needs to be incorporated into your employee handbook. So if you haven't done so already, we can certainly provide you a copy of that poster, and the language needs to be incorporated into your employee handbooks. And then a couple of the other posters here are generally more tailored to a notification of employee rights under the National Labor Relations Act, and then certain employee rights under government contracts. Again, make sure that these posters are properly displayed and are available for review if necessary. So, kind of similar to what Brian mentioned from a wage and hour perspective, it's also important that you conduct privileged self-audits. And again, it's important that you have an attorney conduct these as opposed to a third-party vendor or someone who cannot claim the attorney-client privilege. And why do you need to conduct these audits? These are actually specifically required by the affirmative action regulations. The first type of audit that you need to conduct are of your personnel practices, what we typically call the adverse impact analyses that look at your hiring, promotion, and termination data on an annual basis to identify any potential indicators of discrimination. Second is an audit of your compensation system. We tuned in last month to the second installment. We spoke at length about pay equity audits. These are required under affirmative action obligations, and we've seen in OFCCP audits them asking for documentation that you are conducting these types of audits on an annual basis. And the wonderful thing about doing it under attorney-client privilege is that you can object on that basis and say that you have conducted them, but it's been through counsel, and then the government is not entitled to any documentation related to the audit that's been conducted. And then finally, another audit you should conduct is of your recruiting and selection procedures. And the key question to ask here is, are all of your protected classes being fairly represented in your applicant pools? So again, this looks at the demographics of the surrounding area. Are you in an area with a high African American population or Hispanic population? And if you go and look at your applicant pools and you have slim to no applicants in either of those protected classes, that may be a question to say, are we engaging in appropriate outreach and recruitment for those protected classes to make sure that everyone is on the equal playing field whenever we're trying to recruit talent. So, another thing we recommend from a compliance perspective, this can occur either before or after these audits, is train your managers and supervisors. Question here, are they aware of the company's affirmative action obligations? And do they understand what their role is in meeting the obligations? It's one thing to have the policies and procedures in place. They don't really do you any good if your managers and supervisors aren't aware of their responsibilities under those plans or policies. Are they up to speed on appropriate hiring and selection practices? I mentioned before about the disposition coding. Do they know the proper way to disposition an applicant? If not, that could be an area where you need to conduct some follow-up training here. At the end of the day, the key question is, are your managers and supervisors prepared for an OFCCP interview? During an audit, the OFCCP loves to talk to compensation managers as well as people involved in hiring decisions about the steps that they take whenever they're recruiting or hiring an individual for an open position. So you want to make sure that they understand their obligations and they can speak to them in the event that they're interviewed by the government. So let's say you've engaged in all that groundwork and you have everything up to speed. What happens if you get one of these wonderful letters in the mail from the OFCCP telling you that your facility is going to be audited. From an initial perspective, again, similar to wage and hour investigation, first thing you should do is you should notify your legal counsel and your senior management. Especially if you have legal counsel prepare your affirmative action plans or engage or conduct those audits for you, they're already going to know, any potential issues at that particular facility, and are going to be able to assist you in preparing the appropriate response to the government. And then senior management should be involved because they may get pulled into the audit as well, whether it's through an interview or for providing information, as well as they can speak to kind of the high level or the overall business model that the company follows, and make sure that the government understands why you do things in a particular way. Similar to a wage and hour investigation, you work with your attorneys to limit the scope of the initial response, and this starts with carefully reviewing the scheduling letter and the itemized listing. There are only 22 different types of documents being requested on the scheduling letter, so you should not provide 23 or 24. Initial response should be 22, because again, you're only required to submit what is listed, and then after you've gone through that and determined the proper scope, you can then should finalize your AAP and compile all that support data, and it ranges from documentation of reasonable accommodations provided to data of hires, applicants, terminations, and promotions. You just want to pull all that together into essentially a single submission and have it ready to go to the government. In doing so, you want to identify any potential red flags and anticipate follow-up requests. Hopefully you've done this before the audit letter comes in the door, so you already know what the potential issues are through your self-audits, so then you can prepare yourself what would likely be a follow-up request. And then finally, make sure you submit your response on time. OFCCP gives you 30 days to send everything into them. They do have some limited channels for you to request an extension, where you basically provide a partial submission and then get an additional 30 days to provide everything else. At the end of the day, you at least want to submit something within that initial 30-day deadline. Otherwise, the OFCCP will send you a nasty email letter, and it's just not a good way to kick off your relationship with that compliance officer. I mentioned before, in identifying red flags, you should be prepared for follow-up requests. These are some of the typical requests that you'll see. They always ask for copies of your job applications and self-ID forms. You want to make sure that there's nothing inappropriate on those applications, and they're actually asking the necessary questions. They always ask for an employee handbook and any hiring guidelines. They always ask for a copy of your EEO1 and your VETS 4212 reports. As you know, September 30th is upcoming for the next VETS deadline, which also corresponds with the EEO1 pay data deadline. They always ask for a copy of your contract terms and conditions to make sure there's the appropriate EEO language. They ask for a copy of a job posting and to make sure that the required EEO taglines on there. They want to see proof of labor law posters, as well as verification of those job listings with state and local workforce agencies. Again, that's why it's important that you make sure that you know where your job openings are going, that they're going to the agencies that they should be going to. Some other follow-up requests that might be an indicator of a deeper dive. Again, these are things that hopefully you'll already know maybe coming down the pike through your self-audits. If they ask for copies of the actual applicant flow logs, as opposed to just the data, that could be a sign that they're going to be looking more deeply into the actual job applicants and disposition decisions. If they ask you for a written explanation for reasons of non-selection, or terminations or differences in compensation, again, that could be an indicator that they've seen something in their initial analysis that raises some red flags. If they ask you for formation of pay analysis groupings, that could be a sign that on their initial review of your compensation data, that again, there are some adverse indicators there, and so they're going to ask you to divide your positions up into groupings that are similar in function and what you would consider to be truly comparable from a compensation perspective, so that they can run their statistical analysis on their end. If they ask for summaries of assessments of outreach and recruitment efforts for a particular protected class, this could be an indicator that they're either looking at potential hiring discrimination, or when they look at everything together, they don't think that you're pulling applicants from a certain protected class in the same volume that they would expect for the geographic area. And finally, if they ask for copies of individual job applications and interview materials for applicants and employees, that's an indicator that they're really getting into the weeds with everything, and could be a sign that they're going to come back and ask to conduct interviews or even schedule an on-site audit to come to come to the facility and talk to people and make sure everything's squared away. So again, this is obviously a lot of materials, a lot of things to think about. Whether if you're in an OFCCP audit or a potential Department of Labor audit, if you take the steps that we've discussed today, now you'll definitely be in a much better position should an audit or investigation come in the door than you would otherwise be. So I think we do have just a couple minutes left for questions. I know we have one that came in during Tom's discussion about the FAR clauses, where the question is, with respect to the non-segregation clause, does this mean that the clause prohibits employers from having female and male designated restrooms at a particular facility? So Tom, what are your thoughts on that one?
It does not prohibit having male and female designated restrooms. If you only have one restroom, however, you would have to make it accessible to both male and female.
Yep. And just one other point on that is, under the affirmative action regulations, they do extend protections to based on transgender status. And so one issue you've run into is how to appropriately deal with a restroom situation for someone who identifies as a different gender than their birth gender. And that's a situation where you should really reach out to legal counsel to get an appropriate opinion, because it really depends on the particular circumstances at issue in that type of a situation. So with that said, do we have any other questions at this point?
Matt, there's one from we received here, and I guess I'll ask, it can go to either you or Brian, I think, but is it possible to request request DOL to come in and do an assist audit where one is not scheduled, but you would like them to do an audit? Is that possible?
I think from an OFCCP angle, that is not something that is possible, and it's definitely not something that we would recommend, because that automatically would give the OFCCP access to your location, and could then set up that location for a potential audit down the road, or would allow them to basically freely or voluntarily start sniffing around to see if there are any potential issues. But that said, the OFCCP does offer some voluntary compliance assistance through their website, and they do also have a hotline that you can call where you can essentially, anonymously seek compliance guidance from them from an affirmative action angle.
And one last question: if during your compliance audit you discover that there's a problem, would that then would that then be something that should be considered for making a mandatory disclosure to an agency IG?
Yeah, I think that could create a situation, because one of the OFCCP's enforcement mechanisms is they can direct a contracting agency to withhold progress payments on a government contract, or even seek debarment for blatant violations or non-cooperation. So if it's something that really involves violation of the FAR clauses, because the equal opportunity FAR clauses are the backbone and the starting point for all these regulatory obligations, whether it's from affirmative action or from wage and hour prevailing wage. And so if you're violating the regulations, you're most likely violating the EEO FAR clauses, and it's my understanding that those types of violations are something that would need to be reported.
And I would add one thing, Matt. If you make a disclosure under the mandatory disclosure rule, you would be exempt from any whistleblower complaints. So there is an advantage of making that disclosure.
Right. Yeah, because at the end of the day, I think if during an audit a violation is found, the government's already going to know about it. So then going through the mandatory disclosure process, it's you're really not, you're not teeing yourself up for, the DOL to catch you in a trap, because they're the ones who have identified the potential issue there. So with that said, I think we are out of time today. Thank you to everyone who attended the webinar today. If you have any additional questions following today, please don't hesitate to reach out to any of us. But our next part 4 of the series in the webinar is scheduled for September 26th, where we're really going to get into a deeper dive of prevailing wage, benefits, and leave compliance under both the Service Contract Act as well as the Davis-Bacon and Walsh-Healy Acts for government contractors. So with that, thank you again to everyone who attended, and hope you all have a wonderful afternoon.